Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Good morning, everyone. Welcome to another edition of the Empowering Plans Podcast. I'm your host today, Brady Bizarro, SVP at the FIA Group, and happy to be joined by Brian O'Hara. Brian, want to introduce yourself for the folks that probably already know you?
Good morning, folks. My name is Brian O'Hara. I'm the director of the negotiations wing of our provider relations department. Good to be here with you this morning, Brady.
Awesome. You as well. And, I picked a fun case for us to talk about, Brian, because it's a case of first impression, which us lawyers love to hear. Means the court hasn't tackled this particular issue yet. And this actually came across our airwaves, so to speak, last week. Someone actually forwarded this email to me about this interesting case involving EOBs and a defamation claim. So that's what we're going to cover today. It's kind of a case that really sits right at the intersection of a lot of things that we deal with in the industry daily: plan language, claims and appeals, vendor issues, plan administration, and providers, of course. So I think it'll be interesting to go through the facts here, figure out what happened and what kind of takeaways we can have here for the audience. But let me kick it off for you guys by just kind of explaining what this case is about. The case itself is, I believe the doctor's name is Ahn, A-H-N. So it's
Jeffrey
Cigna.
Ahn. Yes.
Jeffrey Ahn. There we go. So let me get the case name here. Is it Cigna? Is it Cigna versus Ahn or Ahn versus Cigna?
Ahn versus Cigna. Yes.
Yeah. So that's the case if you want to look it up. But so Dr. Ahn is, and I love I have this great pronunciation of this type of
I
doctor.
actually looked up the pronunciation earlier. Otolaryngologist.
There you go. I did too. An otolaryngologist or gologist, not geologist. You sure?
Not. There's no J. Otolaryngologist. Yes.
Otolaryngologist. Okay. We're just gonna say Otto for short for the rest of this podcast. But is
Doctor.
that the ear,
Just
nose,
call him
and throat
doctor.
doctor? Is that what that is? Is it ear, nose, and throat? I think
I
that's
believe
right.
so. Yes.
It's shorthand.
Yeah.
Well, very distinguished doctor here. You'll see in a second gets a little touchy when he's accused of being unlicensed here. So he practices in New Jersey and New York, and he is out of network with Cigna, but he often treats patients that are covered by Cigna's network. And so what happened here is a number of claims came in and they were denied by Cigna for, and the EOBs that were issued to the patients here stated that the claims were denied because the services were performed by an unlicensed provider, which, right, the implication being that Dr. Ahn is performing services and is not properly licensed. And so in response to those denials, he sued them for defamation per se, and tortious interference. So kind of a interesting way of repackaging this dispute over an EOB in a way that we have never seen before, and neither had this court in the Third Circuit. So initially here, his claims were thrown out by the district court. They were granted, Cigna was granted summary judgment, and the Third Circuit ultimately affirmed that. So kind of an interesting case though, because it gets at the notion of ERISA preemption for one, right? And sort of what information you should be putting on your EOB. So Brian, what was your sort of initial impression of this case and sort of the different issues at play?
Sure. Yeah. I saw this and, you hear the word EOB and you think, oh, you mean that thing that comes in the mail that you look at for 2 seconds and then you ball up and throw against the wall, hope it banks off into the trash? Yes, the EOB. But it's actually a very important document for plan administration. My first impression when I read this was, well, this means that plans now have a right to just say whatever they want about doctors. Now, is that a correct assessment?
So it's not, but it's a little more nuanced, right? Because we're talking about the EOB as a form of communication. So This is why ERISA preemption sort of came up so prominently in this case. And as a quick refresher, right, for our listening audience, Section 514 of ERISA has a preemption clause that preempts any state laws that relate to an ERISA employee benefit plan. And there's a number of Supreme Court cases that have went on to flesh this principle out more and say, what does it mean when we say relate to? It's basically if a state law interferes with, or if it sufficiently relates to, if it interferes with, there's basically a threshold. And if the state law crosses that threshold, the courts are going to hold those state laws to be preempted by ERISA. I mean, they won't take effect. And if you think about, why that's the case more broadly, of course, the intention of ERISA was to have a uniform set of laws that plans would follow. And if you exposed every insurer to state laws, certainly state defamation laws, for example, then the information that you'd put on each EOB would have to be tailored very carefully to avoid getting tripped up by various state laws, including in this case, defamation laws. And so one way to think about it, and I think this is actually an interesting analogy, ERISA preemption is like noise canceling headphones for plan administration. So, and that's kind of what you get here, because we want uniformity. So the thinking from the court is that, and the reason why Cigna won is that ERISA is going to preempt this claim. It's just practical, right? It's a practical reason. The EOBs are the vehicle for communicating to participants, and the statements explaining the reason for the denial are kind of inseparable from Cigna's ERISA claims administration function itself. So, they didn't say here that defaming providers is plan administration, right? They said that communicating benefit determinations through EOBs is plan administration. So, you're not supposed to editorialize about the provider on the EOB, but what matters is you have to have like a legitimate reason, right, backed by the plan language to either deny, right, the claim, or if you're paying the claim, you got to explain sufficiently on the EOB. So why does this matter? What do you think, Brian? What are the takeaways sort of for plans, or what should they kind of take from this case that's important for them as they write their EOBs?
Well, I think that there's a few takeaways. I think it's really important that plans audit their, high risk EOB denial language. So looking for denial codes that involve provider licensure, credentialing, provider eligibility, network status, things like that. These are the categories that are probably most likely to create some sort of reputational or, provider relations disputes. Avoiding any kind of conclusory language saying like the provider is not licensed, the provider is not a doctor, something of that nature. You really want to base your language in the plan. So, using plan-based wording, assuming it's accurate, like this service is not covered because the provider does not meet the plan's eligibility provider requirements for this service. Something of that nature. Building administrative record, preserving the ERISA status of the plan, the governing plan terms, claim notes, the source of the licensure, credentialing information, things of that nature.
Yeah, I think, to your point, Brian, right? Like those are all the takeaways for plans in terms of EOB, construction, and EOBs are one of those things that should be standardized. You shouldn't really be editorializing on the EOB, right? And that's just because in this case, the plan sort of escaped responsibility under the ERISA shield, right? It doesn't mean that you should be careless or reckless with how you're describing claim denials, because the court even says, right, like while this particular communication is protected, other letters, communications to the provider, or could open the door to a defamation suit, right, where you're not protected by the claims administration element of ERISA, right? So you wouldn't have preemption in that case. So you don't want to get sort of used to or lazy or sloppy with how you're characterizing providers out there. So because you still could be at risk for sure.
Brady, I did want to ask you, what are some takeaways for non-ERISA plans? So like government or church plans, how does this ruling affect them, if at all?
Yeah, that's a good question, because if you're not if you're not an ERISA plan, right, I think the preemption argument's a lot weaker, because you literally don't have the argument to make. And so I think you could be sued for that, and that would probably be another first impression case. I'm not sure how our court would handle that. I suspect if you were, my opinion at least, is the provider was a little bit jumpy they weren't outright saying that you're not a real doctor, or, you're not licensed. They said like services were performed by an unlicensed provider. That doesn't seem to be that could have just been a mistake, right? Maybe they didn't actually target this particular provider here. But I think the case would be much weaker, certainly, if it's a non-ERISA government plan or a church plan. You don't have that ERISA preemption argument, and I think that a provider could win that kind of a case. Oh, I think a defense would be, again, and I'm not sure this is the case here, but is this the case where the provider is basically just trying to repackage a dispute, right? Is a dispute over a denial of claim? They're trying to just repackage it under the guise of defamation to get claims paid? Maybe. And ultimately in this case, right, some of the claims were actually ultimately paid. So,
Yeah.
you can't really tell what's happening with the provider, but if I were a non-ERISA plan, I would be much more careful with the wording I use.
Yeah. And as we know, defamation cases in general are extremely difficult to prove. But, I think one of the takeaways here is that, regardless of whether you're an ERISA based plan or a government plan, church plan, you want to be careful with your wording. You want to make sure that it's rooted in plan language, that it's defensible, that it's like this podcast, boring, because you don't want to put yourself in a situation where you can give a provider that avenue to seek redress. Because, like you're saying, is this actually a legitimate defamation case, or is this just kind of a different avenue to seek payment? It's probably the latter, but you don't want to give anyone any kind of ammo to bring a suit like this in the future.
Absolutely. Yeah. And you use the word boring. I would take umbrage with your characterization of the podcast as being boring, but certainly EOBs are designed to be boring.
That's all.
Right. Yeah.
You've been
of course.
riveting.
Get a tune to Adam's Health Sense podcast. That's much more entertaining for sure than ours. But no, in all seriousness, sort of as close this one out here, this case, very interesting, clever methods by providers. I think again, the larger example here is that providers are trying new ways of getting claims paid, of fighting against plans and preemption. And I think this was an interesting case for sure that tests the limits of preemption. And frankly, we've seen some erosion of ERISA preemption by the Supreme Court in other areas. I'm thinking more of in the PBM world where they've allowed certain state laws to take effect there. But I think in this case, this is a good result for our clients in our industry, because if you thought that the concept of preemption was on shaky ground, which I think you could argue that it was in the last couple of years, this sort of reaffirms some of the guardrails that are important for our clients to keep in mind. And I'm happy this ended the way it did. But again, still not a license to be careless. Be boring. Boring is beautiful. Boring will keep you out of court and cost you less money, because ultimately, even if you're going to win this case, you don't want to spend your time and resources going to to court and through discovery for something like this. So train your teams.
Exactly.
And if you have any questions about is my EOB sufficient, you can always send it to our ICE team. We'll take a look at it, or provider relations team for that matter. Both of us can handle those kinds of questions and make sure you're using the right remark codes, and as limited comments as necessary to get the proper point across regarding the reason for the denial. So, alrighty. Any final words, Brian, on this fun case?
It's been real. It's been fun, but it hasn't been real fun, Brady. No. No, I think we got the point across.
Yeah. Providers are jumpy, right? That's the take. Providers are jumpy. So be careful when you're coming at them. So on that note, I think we'll leave it there for now. I'm sure we'll come back next time with some more interesting cases. There's always one out there that catches my eye that, moves the ball in one direction or the other. So on behalf of myself and Brian O'Hara and our producer, Pat the Man Santos, thank you all for tuning in to the Empowering Plans podcast, and we'll see you next time. Take care.
Thank you, Brady.